Welcome back, everybody, to the We Win in July podcast. I'm Tyler Todd, your host, sitting here with my co-host, Jaron, the Snow Canyon Man Sandberg. Good afternoon, everybody.
Good afternoon.
You do a good afternoon. You know what? We didn't talk about, and it's come out recently, and I think we've done a podcast since. Blake Lively, Ryan Reynolds. You hear about the Baldoni lawsuit?
We got to do a recap on that.
Can you guys believe? I mean, look, I want to break it down just a hot minute from a legal perspective on what happened, because I think everyone's been freaking out. But honestly, I haven't seen social media go as crazy about it as I thought they would, to be honest. But Baldoni's lawsuit gets dismissed.
Tossed
the $400 million lawsuit, countersuit, right, gets dismissed, tossed out. Why aren't we talking about that? Do you know what happened?
So my understanding of the procedural thing was that he basically, because the New York Times made the statement and they hadn't met their burden that they had met their burden that it had to be false, or they knew it was false. So basically on its face, you don't see a lot of lawsuits thrown out on their face, right? Me and you know this.
Yes, and that's actually, to be honest, so that's why I want to talk about it real quickly before we get into some other cases that we're dealing with personally here in this office. But that was pretty wild. So yeah, it's a very simple procedural rule, and it just basically means that so they filed a motion to dismiss for failure to state a cause of action. Okay. Yeah. And I'm not sure what rule the civil procedure is in New York, but in Utah, I think it's Rule 9, right? Does that sound right?
There's a couple of them that could
fall within but I think it's in Utah's Rule 9.
There's pleading requirements, and then there's some that are on the motion dismiss, which is 12.
Yeah, so it could have been Rule 9, Rule 12, and Rule 12. So I was just shocked that Baldoni's attorneys didn't, I don't know, maybe present or draft the complaint well enough to avoid that, because it's actually not that difficult to avoid.
Unless, and this is where it would be the greatest. Because how did you feel? I mean, I know from our previous podcast, I think we both were Team Baldoni. I think that was apparent.
I'm still Team Baldoni.
So, was this complaint the greatest PR move ever with no substance?
I haven't thought about it that way.
Right? Because they won. I feel like they won the court of public opinion, and yet they might have just lost in a major way. I mean, getting your case tossed out. Now, the statute of limitations is not run. They can refile the case. Fix their pleading. And so most of the time, whenever there is pleading issues, you do see motions to amend the pleading and, fix what was missing.
Well, to be honest, that's why it was a bit surprising that it got tossed, because procedurally that should have been a simple fix.
Yeah. And do you feel like you haven't heard a ton from Blake Lively's team on why not do a victory lap?
No, that's what's so interesting. And maybe they have, and it just hasn't been
blown up
on
or
everyone's feed or whatever. Now, I think she did make a public appearance either that evening or the next day, kind of to some degree gloating a little bit, which, okay, fair, right? But procedurally,
this is a big miss.
It's a miss.
Skills-wise.
It's a big miss. And I think we were all way to go, Baldoni's lawyer, on the way that they were kind of handling some of maybe the media attention and some of their comments and scorched earth type comments.
Oh, it felt like they were winning on every issue. They had great evidence to back up claims. You were like, oh, I mean, me and you have read the pleading, but I'll be honest, I had not analyzed it from the sufficiency of the pleading side of it.
Well,
ours was mostly the evidence countering their evidence, and again, the PR side of it, I feel like they won.
Well, that was a big part of it. I mean, from the court of public opinion, which is oftentimes what you're trying to avoid, because you do want objectivity. Yeah, you're dead on. We were. So I was a little shocked. So interesting. That was interesting.
Yeah. The legal hat on you has to be screaming because is this a malpractice? I mean, there's a lot that opens up unless they knew.
Unless, like you said, they were really trying. It was just more of a,
you're going to lose, but we're going to win the court of public opinion with this.
Yes, and so that we can maybe resurrect your career a little bit or save it to some degree by filing, knowing that we don't have much to go on.
Yeah.
And but by that time the damage had been done or the victory had been won.
Yeah.
For Baldoni, right? So interesting little plot twist with that dismissal of the lawsuit. I haven't seen anything that they've refiled or amended.
I haven't seen that yet, but we could do that on a different episode.
Yeah, so just wanted to throw that out there. That had been done recently, and so I'm curious about y'all's opinions on that. But yeah, that did happen. Interesting side note there. So back to what we really wanted to talk about, because that was a little bit of a...
Look, we do sidebars here in this podcast. Let's not, I mean...
It's an okay sidebar.
That's a good sidebar.
Yeah, that was a decent sidebar. So, talking about like real cases that we've dealt with and resolved recently. So, if you haven't seen it, we have our settlement belt here. You want to show the settlement belt?
Yeah, settlement belt for the... I love how loud that chain is. Now I know why they have the plastic on it.
Look, we have a settlement belt.
For the cameras.
And this is super important. So... we were talking about cases we're handling in this office, and I think something that we've talked about recently, this is important to me, is that insurance companies, and hopefully if you guys are involved in an accident case, wherever you are subscribing or listening or watching this podcast from, and you're involved in an accident case, I promise you, unless you're missing a leg or you're paralyzed, which God bless you and wish you all the best, the insurance company is really not going to give really legitimate credence to your injuries. Okay. They're either going to try to minimize it by saying we're not at fault, or two, they're going to minimize your injuries by saying it's not that bad. And a lot of you may be frustrated with your lawyer right now because they're just not doing a great job. That may or may not be true, but I can also tell you that what is true is the insurance companies are making it hard on you because they don't want to give you any sort of validation for what you're going through. So be prepared for a fight because we do this every day and we know that's what they do. So we want to talk about a couple of cases where that's exactly what happened. So first case, rear end impact, okay? And from all accounts, if you looked at the vehicle that our client was in, it didn't really look that bad. And sometimes when we evaluate cases and we look at the property damage, whether it be to a motorcycle, truck, car, or whatever it may be, sometimes you look at those and you're like, because if we're looking at that kind of scratching our heads, what that means is a potential juror might look at that photo and scratch their heads.
Yeah, and that's me and Tyler have had this happen. The client sends in the picture. I've got one right now. The client has a concussion, diagnosed concussion from the hospital, and the police officer hasn't sent the photos yet, and our client, was in the ambulance, didn't take any photos. But I just watched the dash cam footage, and I'm looking at the back of this vehicle, and I'm not seeing anything. I mean, maybe some paint scratches. No visible dents, and barring that Hyundai built the
most indestructible
vehicle ever, there's metal plating under the paint or something. There's not going to be a lot of, what we typically will call sexy accident pictures.
Right.
Now to our clients, it's not sexy, it's their worst moment, but there's not something that we believe a jury is going to look at and go, oh my, there's not going to be a gasp when we reveal that picture.
We may not even reveal it, to be honest, because if we're looking at that, saying that, and kind of critically analyzing it in that way, that's probably what a juror might do in the same thing, right? And so when we try to then present a number of evidentiary records about the injuries, they're going to be like, wait, how?
Yeah.
And so that's what insurance companies are automatically looking at too. So I guess to give some legitimacy to their evaluation, if they're looking at it, we're looking at it, that's what a jury is going to do, the same thing, right? Yeah. So from this particular case that we're talking about, that's what the vehicle, it just didn't look that damaged. Now, if you look at the photo of the vehicle that hit this client, then you're like, okay, I can get it, right? I mean, there's some moderate damage, like the front bumper and hood was
almost like a croquet ball, where
pretty crinkled.
The back car crinkled, but the impact, our client's car, maybe was a little better built.
Yeah, maybe.
What was the two cars? You remember the models at all? I don't mean to call you out. We can find.
No, I mean the at fault vehicle was like a medium-sized older sedan.
Okay.
And our client's vehicle, for the life of me, I can't remember what it was right now.
Yeah. But their vehicle was obviously the one that came out of that collision.
But there was very
better off.
Visible, not much visible property damage to ours.
Yep.
But our client was in a situation, a physical condition that made this particular client more susceptible to injury. Okay.
Like an eggshell skull
kind of like an
situation.
Eggshell plaintiff. I don't know if any of you guys have ever heard that before, but that's something that we have in the law, eggshell plaintiff. Okay. Which means that if you're already kind of brittle, or fragile, then the insurance company has to take you as they find you. And if you're brittle or fragile and you crumble, right, in the accident, then they're responsible for that.
Yeah, they can't just say like, well, a normal person wouldn't have got hurt, but because you have this pre-existing thing, we don't have to pay you. We just have to pay you what a normal person would have done.
Yeah.
Instead, they have to kind of take you as they find you.
They take you as they find you. So maybe there are some arguments there that there are some pre-existing issues, but eventually, and when we first evaluated this case and when we first got these offers from the insurance companies to resolve the case, we're talking like $20,000 and $30,000 and $50,000. Okay. I think their best offer was like $60,000 at one point because it did result in some surgeries. Now, there had been some previous recommendations for surgeries, but it resulted in surgeries and some pretty significant medical bills and related to surgeries. And then obviously there's arguments about inability to work. So there's lost wage claims.
Do you think a lot of it was initially because do you think reserves were set based on those initial photographs of the accident?
That's possible. And that's a great question. And so what Jaron just asked was, were reserves set? What that means is insurance companies will automatically look at photos of the vehicles or maybe talk to their insured.
Yeah.
And because more likely than not, their insured was like, I hardly hit them.
Yeah. Their vehicle had no damage.
My vehicle had a little damage, but nothing bad.
Yeah, we always hear these recorder calls. And they always minimize everything.
They minimize everything. So immediately the insurance company of the at-fault driver, and if I recall correctly, this was actually, the driver was not insured.
Okay, so this was mostly UIM.
So the driver did not have, and I don't remember whether it was a lapse or lack of payment or just didn't have it on that car.
Yeah.
So this was an uninsured motorist claim against our client's insurance company.
Yeah.
So PSA, real quick, if you don't have uninsured motorist coverage or underinsured motorist coverage, get it. Talk to your insurance agent because more oftentimes than not, you got people driving around you all the time right now in 2025 that are, I think, either intentionally, there are people.
Yeah, I agree.
Or unintentionally driving around without insurance, like no insurance.
Or they're driving around with a minimum policy, which is almost just as bad.
It's almost just as bad. And depending on what state you're watching this from or listening from, those are like $15,000, $10,000.
Well, and even if you're in a state that it's better, the people visiting our state are also from those jurisdictions. So you get hit by a California driver, they're going to have minimum policy.
And we're in Utah. The minimum policy here is $30,000. So sometimes when you have, pretty bad accident with catastrophic injuries, $30,000 is nothing.
We can tell you right now, your life flight bill will be more than that $30,000
immediately.
More.
So if you don't have it or you don't know, find out whether you have uninsured and underinsured motorist, get it. Okay. Because that's exactly what we went against in this particular case. Because the at-fault driver was not insured. Thank goodness there was uninsured motorist coverage on this particular policy. So we were able to pursue it. But that just highlights like the complete unreasonableness of the offers. This is his own carrier.
The one he pays premiums to every month.
This is our client's own carrier. And this happens all the time, you guys. I promise you this too. Even though they're your carrier and you've been with them for 20 years, I paid my premiums, I'm a great client.
Yeah.
They don't care.
And they loved you because you never had any claims till this accident.
Right. They don't care who you are, where you come from, what your name is, how good you bake your bread. They don't care. Okay. They will refuse to pay you because that's what insurance companies do. So their best offer was like $60,000. Okay. Then we had to file suit, but we didn't serve it. We were like in litigation, but not really. And I think it got their attention because we said, look, we're not going to take this word. This is silly. Okay. Got their attention. So we would then.
So you prepared the complaint, but never filed it?
Immediately,
okay.
Yeah. So we're immediately dealing with opposing counsel, which does happen. So what happens oftentimes is the insurance companies, adjusters are like, whoa, this is getting too complicated for me. These lawyers are actually serious. They're going to file suit or have filed suit. We need to get defense counsel involved. Okay. And then defense counsel oftentimes will get involved and be like, okay, let's do some evaluations or let's do some analysis and give some recommendations. So that's what happened in this particular case. And so we worked it up, and there was a lot of back and forth. We actually went to one mediation, like a fight, like really get into the lawsuit mediation.
And some of that is when we know kind of our number of what we think is reasonable and fair, and we know their number. If they are somewhat close, but we're still far enough apart, there's reasons we do those. And it's got to be a big enough case. They don't do these mediations on smaller cases. But on a bigger case like this one was, where the injuries were pretty substantial, we see that more often, don't you think?
I think so. But I think a lot of times there's a push by either the mediators or obviously defense counsel, sometimes the clients, right, to settle the case and be done at mediation. Well, we walked. Yeah. Because I think their best offer then from like what originally was, it went up to like $300,000. And that was like their best offer in mediation.
Now, do you remember what was did our client have a commercial policy that was covering this, you recall?
I believe there was a commercial policy.
Was it a UM plus an umbrella?
I think it was just a commercial policy. Okay.
And a lot of commercial policies, for those listening, typically are $1 million. We see a lot of $1 million commercial policies or more. I mean, we have a case right now with $83 million or $84 million, something like that in coverage. So you see them all over the place. But normally a lot of the commercial policies are $1 million and above.
Yeah, but a lot of people don't even have, a lot of people don't have that. Yeah. You see them, but they're atypical to have that type of coverage, which is another reason why I suggest everybody get uninsured, underinsured motorists, because you just don't see it very often.
Yeah.
And to be adequately insured and covered, because a lot of times the question then is, okay, so what happens if they don't have insurance? What happens next? And you're like, you're cooked?
Yeah, in some cases, if you waived UIM, which we've had that happen plenty of times, all the time. It's like the saddest phone call. Like we had one a couple of years ago. The guy had road rash. Probably on 60% of his body, motorcycle accident. And when I got the insurance company was more than happy to provide me all the places where he'd signed waiving his UIM insurance. And that's like the saddest phone call to make.
That's horrible.
Look, not only was the at-fault party in this one, it was a hit and run. The at-fault party obviously doesn't have insurance, but in those situations where they can't find the vehicle, they then deem that as an uninsured person on the UM. So just the same as if the person hadn't had any insurance. And because he'd waived it, there was nothing.
Nothing.
And
there's nothing you can do. And in Utah, which is where we are, by law, you have to submit a waiver. You have to sign a waiver. And they have to produce that. And if they can't produce it, then we can actually pursue a UIM claim. But more oftentimes than not, they've dotted their I's, crossed their T's, and they have the waiver.
They just dot their T's and cross their I's. That seems like an insurance thing to do. Sky caught that.
That's an insurance thing to do, for sure.
They would do that.
Yeah, they would do it.
Add those little double dot things, above the U, whatever that's called.
I don't even know. But they do it. I
like it.
But it's super important to have it because in this particular case, he had it. His client had it. And so we were able to pursue it. But we walked for what seemed to be a lot of money post what we thought was the original best offer.
Yeah.
And then we got a mediator proposal, which happens sometimes in mediations where the mediator's like, look, I think you guys should settle this case around this particular, this amount.
Well, maybe walk through that a little more, because I think I've had a lot of clients that they really get confused on what the mediator's proposal is. I think this is kind of a cool mechanism.
Well, one thing that let's back it up one sec, like maybe a little farther than that. What is mediation?
Yeah.
And a lot of times people are like, okay, so we're going to mediate. What does that even mean? Well, mediation just simply means that we're going to get all the parties together with a mediator who's neutral, and the mediator will go back and forth and kind of present strengths and weaknesses to your case. Oftentimes the mediators we use are either defense lawyers or judges or, people that are familiar with personal injury cases.
And it's not like the movies where we sit across from a table and like chew each other out, right?
No, we don't even, oftentimes we don't even see the other party or the other lawyers. So that person just goes back and forth to the rooms, presenting offers, arguing some of the strengths and weaknesses of the case, and also letting our clients know, like, look, your attorney may have tried to explain this to you, but sometimes, because
getting a second opinion probably helps them feel.
But clients are lay people. They're not experienced in this. And even though sometimes we explain it, sometimes it's just not sinking in, which is fair. And sometimes the mediators will say, hey, this is the way we see it. And if I was on this case, either as the judge or as the defense lawyer or the plaintiff's lawyer, these are some of the things I'd be concerned about, or some of the things I'd be feeling good about and encouraged about.
Yeah.
So it helps to have some objectivity, right, in the room to say, hey, these are strengths and weaknesses, and this is what, if I were you, I'd be concerned about. Okay. So mediation's not obligatory, meaning, well, sometimes the judges will order mediation right before trial, but when I say it's not obligatory, meaning you don't have to settle the case if you don't want to.
Yeah, if they're offering too little,
if you think it's too little, you can walk.
Yeah.
So it's just an opportunity for the parties to get together and try to resolve the claim, right?
Yeah. Now a mediator proposal. So now
a mediator proposal. Okay. So a mediator proposal is, again, when either the defense is too low, or we're too high, or whatever it may be, and then the mediator's saying, look, I've gone through this case, I've reviewed all the deposition transcripts, I've reviewed the medical records, I've looked at the liability analysis. This is what I think this case would be worth from my perspective, and what the case should settle at. And then the mediator will make a proposal that either party can either accept or reject.
Yeah.
Okay.
And the idea is if either party rejects it, then they don't tell you whether the other party would have accepted it. So I always hate not knowing.
I know. So you're like, did they accept it? I mean, I guess
we're going to reject it, but I want to know if they would accept it.
They would. Yeah. So that's
and they're probably thinking the same thing. Oh, would Tyler have accepted it? Like,
right. So mediator's proposal. So it just gives the opportunity. It just gives an opportunity to the parties to either accept or reject it. Right.
Yeah.
And on this particular case, we were literally like, I reject it. I don't even like.
We didn't even wait the timeline. Did you just call opposing counsel?
They gave a time period, and I just said, I'm just going to reject. I mean, now there was some hemming and hawing back and forth in regards to like, hey, we don't like that number. And so I didn't like immediately, I had to get some approval from the clients as well. But I just said, look, I mean, I didn't send it to the mediator because that's typically how it works. You just send it to the mediator, whether you accept or reject, and you don't send it to the other party. And then the mediator will typically send an email to everybody saying, we have a deal or we don't have a deal, right?
That's how all mine have gone.
And I just said, I don't even care. I'm going to send it to everybody. We reject. Just so everybody's clear, we reject.
You just CC'd the whole group.
Everybody.
I love it.
And just like, look, and so then we did some more working the case up a little bit. And then finally I think we all like, hey, now that we're here, do we want to try to mediate again?
Or are we going to file suit?
Or pursue it. Cause I'm trying to remember if we actually filed it or not, but anyways. So we took a second bite at the apple at mediation, and for a number of reasons, right? And like, again, like every case has strengths and weaknesses. It's like every prince, there's a ward or two.
We felt like the client's injuries were probably good on this one, but again, in the back of your head, you always were looking at those accident photos.
The accident photos, and obviously the other side is going to present a bunch of evidence regarding pre-existing issues and whether the accident actually, in light of the severity of the impact, actually caused the injuries we were suggesting were a result of this particular accident. So yeah, there are some warts, if you will. Now we had some good strengths, of course. And I think that
what do we call the strengths? If warts are the bad parts, what do you call the strengths? Like,
I don't know, dimples.
Smile.
People
dimples.
love dimples.
Yeah, there you go. We had some good winks. I don't know. The opposite of warts. Beauty marks.
Beauty marks. There you go. Beauty marks. So we had some beauty marks too, right?
I don't know. I
don't know. That didn't really land.
We're gonna chew on that one.
Okay. Regardless, we ended up selling the case north of $700,000. Okay. So it's a drastic difference between
the initial
offers of whatever they were, 60, I think what it was, or something like that.
Over 10 times the amount.
To where we finally resolved the case. And I think it was a good result. Now, the hard part with cases and trials and mediations and whatnot, and this is a very real issue that I think we deal with, I think because it's like you always want to win. I mean, that's what we named our law firm, We Win Injury Law. We will always want to win. And of course, that's subjective because what does winning mean? And winning maybe different. Like on a game, it's either you win or lose, right?
Some of us wish we would have called it we win big.
We win big.
Yeah, we win big.
So you know,
the kind of victory game Tyler won.
Yeah, we always want to win big.
We wanted to feel like a blowout win.
Absolutely.
10-run rule to kind of win.
Or 40 points, you know. I mean,
maybe you did 10-run rule. I mean, 10 times the amount. That does feel like a 10-run rule.
Yeah, the game was called early.
Game was called early before we filed.
Yes. So we always want to win big, for sure. But that's without having a crystal ball, and nobody does. Can you always get more at trial? Maybe. Could you get less at trial? Maybe. And that's always the risk, right? You're weighing those things and doing those things, and you're trying to do whatever you can to make sure you're doing the best for your client. That's the key. So it was a big win. 10-run rule win, if you will. And I think that's the key, is that you just have to be ready to fight. And you have to be ready to file and do those things that you are showing the insurance company you're not going to get out from underneath this for cheap.
And willing to walk away from that previous mediator's proposal. Me and you talk about this all the time, and we try to plan, and there's things that come up in mediation sometimes that deviate, but we've typically gone over kind of a walk away number. Hey, here's the lower end of what we think your case is worth, and we talk about those with clients. But more often than not, if something new comes out, like I had a case recently where the mediator brought up that, oh, by the way, your own client's insurance paid for the other vehicle. They were that much convinced that your client's own insurance company did intercompany arbitration and lost.
Right.
And that didn't come out. We'd never, because this was before any of that discovery had come out. We weren't privy to that information until mediation. And so there are things that come out of those mediations that sometimes can move the needle on where our walk away number is. But I think it takes guts just to walk away from that first mediation and tell that. I do love that you said it to everyone, to the mediator.
Well, I want to make sure that they knew that we are not okay with that number.
Yeah.
And it does take some guts. And so we've walked away from some big numbers in other mediations as well. And those are ongoing battles that we're still in. And we'll talk about those down the road when we get more clarity on where those cases are going. But you have to be ready to fight. And you have to be ready to and willing to walk. And again, every case is different, so bandwidths are different. People's circumstances and situations are unique. Yeah. But you have to be ready to fight. And that's the key. And on another matter, I just thinking about this, on another case that we just settled recently, the best and final offer before we actually filed suit was $20,000. On another case that we just settled recently, and we settled that for $500,000. After a number of depositions and discovery and a bunch of issues we had to go through, but 20 was their top and final offer.
Yeah.
And what's that? Is that 10 times?
It's more than 10 times, but I'm not a math, that's not my strong suit.
We 10-run ruled them there too.
I think you more than 10. What's a 20-run rule? I don't even have that number.
Something like that.
That's a pretty good.
So you got to be ready to fight, and that's what we do. That's why we love doing what we do. And it's just fun to talk about these cases and talk about some of the nuances, because and I think if you guys have been watching a lot of these court TV dramas online, particularly Karen Reed and the Baldoni trial we talked about at the start of the podcast, it's just interesting because there's multiple perspectives. And if you guys start flowing through the comments, and I know that a lot of people are like, I'm here for the comments, right?
Yeah.
You see the popcorn box with just for the comment sections. People do have interesting perspectives, and people see things differently. And so what I think is so obvious, right, may not be so obvious to you even.
Yeah.
Or
we've had discussions on cases, me and Tyler, that's one of the things I appreciate, is sometimes me and Tyler have very different views on cases, and we kind of talk them out. And even on, we both have the same goal. We want to maximize it for our client and strengths and weaknesses. And even amongst lawyers, we don't agree on every issue. And so it's good to see sometimes in those comment sections, you see oh, this is not how I pictured this going, or they have a different perspective than me, and that's good feedback.
No, it's great feedback. And I think, quite honestly, I go to a lot of the comments because I'm just curious the way that people think. Yeah. Because that's what we do.
Well, and one thing, me and you just got back from a trial conference down in California, and you go to these and you hear, good victories and different trial techniques, and, we're kind of collaborative on some of those issues, and I love it. But one of the comments that was made from one of the trial attorneys that I follow from, outside our jurisdiction was, he still made the comment, 97% of my cases settle.
Yeah.
I mean, and this is a trial attorney
Yes.
that had some big victories, and I was like, it's validating to hear that not every case this attorney takes. So, because that reflects probably the realistic numbers throughout Utah. I would assume that number's pretty accurate.
Yeah, I was shocked because they're known as a trial lawyer, trial firm that takes most of their cases to trial. And when asked what was the percentage of cases they actually take to trial, 3%.
3%
was his number. And I was like, wait a second.
Now, I've heard this too, and this is how me and you handle cases, at least, is every case we have, we plan on going to trial.
Right.
I mean, that's how we prepare these cases and work them up is, we're not filing on cases that we wouldn't take to trial. We would take every case to trial if we need to. It's just the reality is that cases should and most often do settle. That's a normal number.
Well said. That's well said. It's true.
Yeah.
And I think that's why I say be ready to fight, be prepared to fight, because more oftentimes than not, you have to file suit and you have to then get through the process and make it, and you have to enjoy the process. Sometimes it's enduring the process, but you have to go through the process in order to really put the feet to the fire and make them pay what's fair.
Yeah. And even if what's fair is still in a settlement, it didn't actually go to a jury trial, that's okay.
Right.
Yeah.
Right. So just be prepared to fight. That's what we're telling you.
Yeah.
So
I love it.
anyways, it's fun to talk about cases, and that was one that was really good. There were the last couple, two that we've mentioned were really good results for our clients, and we feel like I know that, and I know you well enough, and hopefully, and I know our team here, and I know our other attorneys in our office, they care. Someone mentioned that to us or to me when we were down at that conference. Like, hey, one thing I can tell is that you guys actually care, and I hope that's true. I hope that's portrayed through all that we do, particularly this podcast, that we care. And we're passionate about getting great results for our clients. So hopefully you never need us, everybody. But if you do, you can find us online. We have our website, which is wewinjurylaw.com. We have this podcast. We have TikTok. We have Instagram. We have Facebook. Find us. If the consultations are always free. And even if it's just a question about insurance or what type of insurance should you have, whether you think you have a case or not, we're always here to be a resource. That's first and foremost. The consultations are always free, and then you don't pay us until we win. So there's nothing out of pocket.
Until we win for you, period.